back to Sunrise Daily. Well, that's what we will be focusing on today. Well, Mr. Chris Akiri joins us now. He's a legal practitioner and also the chairman editorial board of the National Daily Newspaper. Morning, I thank you for coming on today.
It's my pleasure every time.
Well, most recently, I beg your pardon, yes, this CBN matter, of course, taking the front burners. And then you heard the president say he's got absolute powers to suspend the CBN governor. But we also do remember previously that some members on the floor of the House of Representatives have said that there is nowhere that is stated in the CBN Act that the CBN, I beg your pardon, that the president can suspend the CBN governor. What it recognizes is removal, and there's a process, means you have to go through the Senate. So how do you reconcile the president's saying, I've got absolute powers, and those who say they don't see where that is written?
Well, you see, on this occasion, as on some other occasions in the past, I think the president is right, and the National Assembly is wrong.
The House of Representatives, I think, is important to be specific.
I mean, the
some members, in fact.
Some members of the House of Representatives, they are wrong, and the president is right.
How?
How? The CBN Act is there. A cursory look at this, the provisions of the CBN Act relating to the appointment and removal of the governor of the central bank, you know, will show you that they are wrong. Like this, Section 8, subsection 1 of that Act, you know, empowers the president to appoint the governor or deputy governors of the bank. That's there. But then you go to Section 11. If you go to Section 11, subsection 1, you see, the F there, the paragraph F of subsection 1 says the president can remove the governor of the central bank.
Yeah.
Good. Now, so what is the point? I mean, that is there is a provision there immediately that subject to the to 2/3 majority of the Senate.
Yeah.
That's there. But those people who argue that the president cannot remove, they gloss over the provisions of paragraph C of that section. Paragraph C of that section says the governor of the central bank shall cease to be governor of the central bank if he has perpetrated certain atrocities, you know, that can be categorized under serious misconduct. In other terms, gross misconduct. If you read that one, you must construe paragraph C and paragraph A, B disjunctively. It's not saying, when I say disjunctively, meaning not conjunctively. Paragraph C says, if the president, meaning if the governor has committed any serious misconduct.
He was guilty of
serious misconduct. They don't look at that. That is separate from D, from F, which says the president can remove. If you see that proviso, the proviso provided.
Mr. Akiri, yes. How does that work? Perhaps maybe you should clarify again for us when we talk about if he's guilty.
Yes, if he's guilty of serious misconduct.
How does that guilt come in?
Now, we are a governor of the central bank has perpetrated atrocities that cry havoc to high heaven. And you see, I'm not here to say that this governor has perpetrated such atrocities, but I'm saying that where the governor is alleged to have committed such atrocities, then he has to be probed. The investigations have to be conducted into the allegations. And one can cite almost indefinitely examples of such allegations that have been leveled against this governor of the central bank.
The Financial Reporting Council of Nigeria, can we say their report on the CBN governor amounts to an investigation?
Yes, what they're trying to do is to the Financial Reporting Council have identified certain things. And there is this Financial Reporting Council of Nigeria that's mandated to look into the accounts of the CBN. They've looked into the account and then say, come, there is something wrong. So many things are wrong. And then these include the fact that the governor has violated. You know, don't forget that the governor is both the chairman of the board of the bank, is the chief executive of the bank, is the governor of the central bank. The buck stops on his table. Okay. No more than that. So if any allegation is leveled against the management of the bank, he is the direct person. So they say he should be proved.
Yeah, but
and if there is time, I'm going to reel out all of these allegations for which he must be proved.
Before we get to that, in this case,
yes,
I mean, yes, you've talked about Section 8 and 11, then 11C and F.
Yes.
But they are all geared towards his appointment and removal.
Yes.
And of course, our jurisprudence says a man is innocent until proven guilty.
Correct.
By a court of law. So if you're looking at C, which says is guilty of a serious misconduct,
correct,
which precedes his removal.
Yes.
Provided the two-thirds majority of the Senate deems that so.
Yes.
But in this case, it's a suspension.
Yes, it's a suspension. You see, what's there is that if you look at that C in particular, it says if he commits any serious misconduct. Is that not correct?
Yeah, if he's guilty of a serious misconduct.
If he's guilty of any serious misconduct.
Yeah.
Now,
so for you to have been guilty,
now for the person to be guilty, he has to be proved. He has to be judged. The allegations have to be proved. Is that not so?
Who adjudges the person guilty?
No, that's what I'm trying to say. The Financial Reporting Council, it has a duty, or a panel could be set up to look into these allegations, and that is what they are trying to do. And to do that, they have to suspend him, because the chief executive of that organization, of that institution, cannot remain in office while investigations go on. Now, let me say this thing. In industrial relations, there are two types of disciplinary action, or punitive action, that can be taken against an employee. Number one is termination of appointment. Number two is summary dismissal. Now, where it is termination of appointment, there is probably no problem. Now, but where it is dismissal, then you might have problems there as far as industrial relations are concerned. But then the point is that before you decide whether somebody's appointment must be terminated or not, you now set up a commission of inquiry or whatever to probe into this thing. But in probing, you have to suspend. So here is a suspension. And suspension by any definition means a temporary discontinuance of employment while any investigation may be going on. It does not render the continuance of that employment impossible. It does not. It could be recalled tomorrow if after investigation is proved not to be. And now what you do in law is that you can sue for wrongful termination of appointment. You can sue for wrongful dismissal. You cannot sue. It's never heard that you can be sued for wrongful suspension. Here is a suspension. And it's not qualified. The act, that matter is not qualified for any action in court.